All right, so big news in the NFT world. Of course, this is all around the legislation and what the courts have ruled in reference to what's happening over at Dapper Labs. Top Shots will dive into this today. It's going to be a fun one. We've decided to bring in our legal expert onto the case, so I think you guys are going to like it. My name is Paul Barron. Welcome back to TechPath. Let's get into it today, and I want to talk with John Deaton. Welcome him back to the show. Great to have you on.
Great to have me. Thanks for being here, Paul.
Yeah, so John, let's get into a couple of things here. First, I want to jump over to just to kind of give our audience some context. Flow blockchain is the blockchain that's behind NBA Top Shot. If you just look at some of the numbers here on what they're doing, you also have NFL All Day on there as well. But I mean, look at these sales. This is like 1.1 billion in sales, which has been a highly successful overall program for NFTs in general, but more importantly, how major industries are adopting NFTs. With that being the case, and if you look at, just an example here of some of these NFTs, these are kind of like moments that are out there. Look at that, $1,800 for the Magic Johnson moment. That's pretty cool.
Wow. I remember watching that.
Right? Well, that's what makes them so
sure
valuable. Yeah, it's what makes them so valuable, is these great components. But with this being the case, and you see the judge declaration from yesterday, what was your first response when you read it?
Well, my first response was I read the title, and the title scared me because the title that permeated Twitter yesterday was that the judge ruled that these NFTs were in fact securities.
Securities, yeah.
And that's not what he did. And so the first thing I think your audience needs to understand is the context of this decision. This was a motion to dismiss. It's not a summary judgment motion.
Mm-hmm.
No evidence has been provided yet. There's been no interrogatories. There's been no depositions. The case has just started.
Right.
And what the judge does on a motion to dismiss, he has to assume that every single thing that the plaintiff alleged in the complaint is true and accurate, and must rule any inference in favor of the plaintiff, right? Not Dapper Labs. And so all the judge said in this case is that it's plausible that the plaintiff, alleged that this is a security in a sufficient minimum way to survive a motion to dismiss. It would have actually been more surprising if the judge would have granted the motion to dismiss, because they're rarely granted in a situation like this.
Mm-hmm. In the article, to your point that they were mentioning, a couple of highlights that they hit on, and then we're going to go into a couple of the details from the actual PDF of the ruling. Not all NFTs are offered or sold by company will constitute a security, and each kind of be on a case-by-case basis. So I think that kind of sets up a little different approach here. The judge cited the company's control over Top Shots, which is another scenario after they are sold, as well as specific tweets promoting the NFTs in his court filing that used emojis, which we're going to show this. To me, this is where it gets really on the fringe of, these are the kind of things that absolutely now is considered a security contract. And then although the literal, what do you think about that?
Go ahead, Paul.
No, what do you think about
that rocket emoji was used by the SEC against Library, and one tweet by Library on their website, they had the rocket emoji, and the SEC made a big deal about it. So I would encourage any promoter out there to not use the rocket emoji.
This to me just gets a little bit out of control. I mean, securities are a really serious situation here. They've been governed by the SEC since the beginning of Wall Street. We've seen very, I would say complicated, but also to a certain extent, extremely polished security contracts and all sorts of regulations and scenarios like this. And this is boiling down to a rocket emoji as to being one of the elements that tells an investor that you're going to get profit.
Yeah, well, here's the problem is that there's been some appellate cases that have focused a lot on the marketing side. And so anything that promotes profit in any way or implies that there's going to be a potential profit if you purchase this asset is going to be used against a promoter. And so that's, the SEC in the Ripple case, they did the same thing. If there was any comment by Brad Garlinghouse or any tweet by David Schwartz, the CTO, that implied anything, they were all used against them. And so, the thing that's important is what you read, Paul, is that the judge said, look, not all NFTs are going to be securities. Not every NFT out there is a security. And you read something important. He talked about this particular blockchain. He called it a private blockchain. And he said that both the blockchain and the marketplace, and he used the word entire marketplace where the cards are sold and traded, are controlled by Dapper Labs. And so that's a big deal. Like a lot of people, they can't extrapolate this motion to dismiss decision and then say that's bad news for Ripple or XRP or bad news for other situations, because there's a difference between a private blockchain and a public blockchain. There's a difference between whether or not you completely control the entire marketplace versus you don't. And so it's going to go down each of these cases. This is why I said, Paul, I've been saying publicly, all of these cases are going to be fought in the courts, because unfortunately Congress is not going to act. They're just not going to be able to pass bipartisan legislation that's signed by the president in the next couple of years. And so for the next couple of years, it'll be these decisions, and it's going to be on a case by case basis, and you're not going to be able to extrapolate, oh, this particular decision is bad news for the entire market.
So there was a couple of things that were outlined. Dapper does not endorse other marketplaces. This was in the document. When you look at the phrase of not endorsing other marketplaces, does this centralize, I guess, the situation around what this one particular case could be with Flow? What is your opinion? Do you feel like this is a scenario where it could be ruled as a security, the way that Flow is set up with Dapper Labs, with how NBA Top Shots is done?
Yeah, the judge actually went through an Howey analysis in his decision. He went through each prong and simply said, look, the plaintiff here has alleged sufficiently and adequately that each prong is satisfied. And so he gave you a purview of what his actual Howey analysis could be. And those are important factors. I mean, if you control the entire secondary market and the entire marketplace and the blockchain, then there is a good possibility that at least the initial sell is going to be a security, because this judge also said that they used the funds from the initial sell to maintain the Flow blockchain. And so that's a per se like Telegram or Kick kind of scenario where or it's even the ETH ICO, itself, when you raise money and then you use that money and then you build the technology or you maintain the technology. So there is a good chance that the judge could very narrowly say in this particular scenario with these particular facts that it does constitute a security. But everyone needs to understand one little different factor in a different NFT scenario could completely change the facts and circumstances and a decision. And so we're going to get, in my opinion, Paul, what some might view as inconsistent kind of decisions. In one case, it's ruled a NFT is ruled a security. In another case, it's not ruled. And then there'll be these competing, cases going up in the appellate system. And then finally, Congress will enact. But until then, that's what we're doing. There was a civil lawsuit against Ripple in a case that predates the SEC cases. The plaintiff's attorney, someone like me who files a class action, said, hey, we believe the XRP is a security. And I filed an amicus brief in that case because the plaintiff's attorney is trying to claim that all XRP are securities, even in the secondary market. And my position is similar to what we did with XRP holders in the SEC case, is to go in and say, no, you have to limit it to direct sales by Ripple. And so the real fight for the entire market is what you're talking about, is that secondary market sell. And if a promoter says we don't endorse other secondary market sales and we don't endorse any other marketplace, you need to be at the marketplace that we control. That could very well be a security.
Yeah, and back to that point, these were, I mean, if you guys read this, if you go to page 11, there's a section in there that it states, Dapper Labs does not, recognize or endorse other moments being sold, traded outside the marketplace. Then the other fact that goes into is the withdrawal. So, because sometimes these, being able to get cash for the sale of one of the NFTs was taking a long period of time. So again, it showed centralization around this.
Yep.
Back to your point, those could be a scenario where flow could be considered or I should say, the NFTs could be considered in this particular case a security. To your point, how would lawmakers be able to govern? I mean, you look at Section 230 of how they kind of govern the internet and a lot of the content creators and social media companies that essentially have been built over the last few decades. Do you see something like that coming out of DC at some point, something that large and sweeping that would affect crypto and especially the NFT market? What are your thoughts?
I think it has to eventually, because what we're talking about, you're going to get all these inconsistent rulings from different circuits around the country, and it's like the library case versus the Ripple case. One's in the First Circuit, one's in the Second Circuit. So the judge in library he's got to follow appellate cases above him in the First Circuit that's different than Judge Torres in the Ripple case. And so because of the inconsistencies between the different circuits, you're going to get different decisions. And so there's going to have to be, and I think the United States and Congress needs to look, to be honest, to look at the United Kingdom and what they did through their Financial Conduct Authority, Paul, where they said, look, what we're going to do, and they're still working on it, but they identified three types of tokens. A security token, which let's call it the Howey token, if you will, that meets the Howey test, and therefore it must be registered at the SEC. And then there's a utility token and an exchange token, and then there's a hybrid type token, right? And so in the UK, they ruled XRP as a hybrid token, acting in between a utility token and exchange token. And so there is going to have to be comprehensive legislation that lays it out, and how detailed it gets on what decentralization is sufficient versus not sufficient. Unfortunately, the SEC should have followed Hester Peirce's safe harbor provision that basically said, let's come together and get some guidance that says each promoter has 3 to 5 years and lay out some markers, right? Let's call them decentralization markers that, marker 1, marker 2, marker 3. And, by year 3 or 4, you have to meet all 3 of those decentralized markers. You'll be determined a commodity. If you fail, you'll be determined a security. That's what's so desperately needed. And imagine, Paul, where we'd be today if in 2018 we'd have got that kind of guidance, absolutely. And so, unfortunately, we're waiting on Congress to do its job.
Yeah, and I think the key is just like any other technology that's advancing so quickly, it doesn't slow down, and we continue to see these guardrails being banged against by, a lot of creators, innovators. My concern is that we, here in the US, we might use or lose the innovative edge that we had with Silicon Valley and kind of the creation of what we know now as most of the tech community. Because right now we're seeing a lot more activity in Asia, we're seeing more activity in the UK and in Europe. Obviously we see it in the Middle East and even South America to a certain extent. Do you feel like the United States is behind the 8 ball right now and are going to be forced to do something like this before the next term? When I say term, meaning president's term, or do you think this is going to be a longer play for lawmakers?
Well, let's look at what you just brought up. And you talked about Asia leading right now. Let's go back to 2018. In 2018, China outlawed crypto, right? They banned it. And here in the United States, the SEC said, okay, Bitcoin's not a security, Ethereum's not a security, and they try, they put some guidance on. So if you go back to 2018, it looked like the United States was going to lead and Asia wasn't. We fast forward to today, and you have Hong Kong now coming out and being blessed by the Chinese government, where
Yeah.
they want to be the leader, and they're now going to allow trading of their citizens and residents in China to trade crypto. And so I unfortunately do believe that the United States is not going to be the leader, because I don't believe, and I hate to say that, I served in the Marine Corps for 8 years. It hurts my soul to talk like this, but it's the truth. And Congress, when can we expect them to do their job? I've said it's not going to happen before 2025. You're going to have to get another presidential election. You brought up president. That's going to be, in November of 2024, and then there'll be a new Congress that starts in January of 2025. So what can we hope for the second quarter of 2025 before the U.S. does something? As you just mentioned, Paul, this technology is rapid, and how it looks today versus 2025 is going to
It's
be
going to be
not so similar.
insane. Yeah, insane.
Exactly.
Speaking of new technology, I want to get two more quick answers from you. Okay, so another block is a platform that is essentially marketing or developing these music NFTs, and they've done something very unique. They've attached these license contracts. I don't know if you've had a chance to see what they're doing, but essentially it's a music NFT, Rihanna. They go out to the producer or the actual arts owner, and they get the rights to it. Then I don't know if this would be considered fractionalized, but the point is they'll give the owner of that NFT a contract that sets outside the traditional contract. It's built into the NFT contract, and they get aspects of royalties from that music. With that kind of scenario, I know maybe you haven't had a chance to look at it, but what are your thoughts on that as to whether or not NFT holders could get royalties and whether or not those royalty contracts are actually legal?
Well, this is great and cutting edge stuff, and it's where the securities laws and technology, the rubber's meeting the road. But I think what you just described, I haven't looked at that specific project. However, Paul, you and I, you especially have discussed on your channel the tokenization of the world, right?
Right.
And how everything's getting tokenized. And so I think that if LeBron James was coming out today, a phenom like him, you would even see his entire contract tokenized, and individual fans could get a piece of his contract and royalties. And whether it's, the Empire State Building or Trump Tower or any of these, residences or commercial real estate where you become a rental shareholder, if you will, participating in the rents of commercial real estate. And so I'm someone who believes that the tokenization that you're talking about, and ownership and royalties or rents and all of those things, we're just starting to scratch the surface, and I think it's going to explode as we move forward.
Well, it's
now whether or not, and that's why I said that there's going to be litigation along the way, right? There'll be some attorney who comes along and says that what you just described with Rihanna, that's a security. They'll say that the person's relying on the efforts and talents of Rihanna, to gain profit. And so
right.
It'll be interesting. And so we're just desperately going to be in this sort of limbo stage until we can get Congress to lay down the rules.
Yeah. Okay. Last topic to you. This was a tweet you put out, and I was just kind of curious on this. If the court applies the laws with the facts, this was about Grayscale. Let me zoom in on that for a little bit. The Grayscale will win, and this would be the ETF, the spot ETF. So you feel pretty confident that this could actually come to light?
I do. I'll be a bit surprised. I can't say shocked, but I'll be surprised if Grayscale loses. I was someone who, when they denied Anthony Scaramucci's, I tweeted him and said you should do what Grayscale is doing, and Grayscale eventually did it. And so Professor Joe Grunfest, who teaches at Stanford Law, He's helped with ETH. He's helped with XRP. He's probably the most revered SEC commissioner in modern history. He's come out and said that it's a clear-cut case. It is very arbitrary and capricious, and that's the law. Is the SEC's denial arbitrary and capricious, or is it well-reasoned with the facts and the law? And when you think about it, how do you justify a short ETF for Bitcoin? And how do you justify a derivatives and futures for Bitcoin for the last few years, but keep denying a spot ETF? So I predict a win. I know a lot of people are going against me, but I predict a win for Grayscale.
John, this is more speculation, but I just look at it this way. You've had a chance to go against the SEC head-to-head here. Why do you think that the SEC is being this way? Why so contentious? Is it just because they're trying to get this early land grab from a legal position, or do you think there's something else afoot here?
I think that you have, you could go back on, and I have it on my Crypto Law channel. You have Gary Gensler at MIT, Paul, where he's talked about the monopolistic nature of the banking system and how any disruptive technology has to meet the fight by the incumbents. And so, yes, part of it is this land grab, right? The SEC wants this nascent technology and they want to take jurisdiction. So, they're like basically filing all these enforcement actions. But I honestly believe that Gary Gensler is an agent for the incumbent system. And I believe he's protecting the incumbents.
Yeah.
We use his own words against him. And I went on Charles Payne's show on Fox Business and I said, listen, what's happening here is that at some point they're trying to crush this market, and then these legacy incumbent players will come in, they'll get a bigger share, and then all of a sudden when BlackRock, Fidelity, Goldman Sachs, and JP Morgan, they got a much bigger grasp of it, then all of a sudden they'll loosen the reins and then they'll come together and there'll be some kind of guidance. I believe in my heart that that's what's happening.
Yeah. John, always good to get your insights on this stuff. I know you have to run and catch, get to business, but thank you so much for stopping in today. We appreciate it.
Thank you for having me, Paul.
All right. Thanks again, guys. If you're not part of our Diamond Circle, make sure and jump in on that. We're going to leave the link down below. You can actually go through our website or join the Substack, which is where all of our Diamond Circle content now resides, including a podcast and a lot more analysis and insights. You can even get kind of a do-it-yourself CPI over there as well. So make sure and join that. And of course, if you guys, first of all, drop some comments and some likes below. If you like these kinds of deep dives and these impromptu interviews, and obviously John Deaton was so kind to give us a quick interview on this situation with NFTs and what's happening with Dapper Labs. But make sure and drop some comments. Let us know, and also our guests know how much you appreciate their time and efforts. Of course, if you guys want to reach me, it is out there on Twitter @Paul Barron. We'll catch you next time right here on TechBath.